TVC Security Services Limited has inaugurated a JAM computer-based test center in Ogulago community, Burutu local government area of Delta State. This initiative aims to provide convenient access to UTME examinations for students from riverine communities.
Assessing educational facility for students in rural riverine communities like Ogulaha is a tough task. Sometimes it involves traveling long distance, but not anymore with the inauguration of this state-of-the-art CBT center. Initially called the Ogulaha Kingdom Cyber Cafe, an ITC training center for students and rural dwellers, but was upgraded to an approved JAM center by their representative in Burutu Federal Constituency last year. TVC Security Services Nigeria Limited renovated and equipped the JAM center with 250 new laptops, a 30 kVA solar inverter system, and an air conditioning system. The facility has been renamed Solar Epimopolo CBT Center Ogulaha in honor of Tom Polo's late mother.
It's your project, especially for the youths and the children coming out of secondary schools. Education doesn't have an age limit, so even the elderly ones can still want to go back to school and use the facilities. So we urge everybody, the youths, the children, the parents, the teachers, to make sure that this place stands as a test of time. The name of the place is Solar Epimopolo CBT JAM Center, and I believe it's the name of a mother, of a matriarch. So it's a standing legacy for her memory.
The stress of going to the interland to register for JAM and to sit for JAM is a thing of the past with this present program. So it's of big benefits.
TVC Security Services has done it again for our people by upgrading the Solar Epimopolo JAM Center Ogulaha to an international and world standard.
The project aims to ease JAM examination access for riverine communities.
It was not really okay, but now we have our own center here where we can write our own JAM. We are happy and it's preferable. We are glad for what they did for us.
There are people that leave this town to travel to other towns to write their JAM, but me, to get my own turn, I'm happy and proud.
Sokabolo, Yobebe, Ogbotobo 1 and Ogbotobo 2, Osen, Yokri, and Obugoro are other communities in Ogulaha Kingdom that will also benefit from the upgraded JAM center.
Let's get back to a conversation, everyone. Barrister Osiolisa, constitutional lawyer, political affairs analyst, is my guest tonight. Mr. Olisa, thank you very much for staying with us on the program. So I was asking, what are the options available for Governor Fubara in the proper handling of these issues? I mean, citing some parts of the Supreme Court judgment, the Supreme Court rules that only the House can declare a seat vacant for defection and not the governor of a state. Not even the court can do so. But they claim that the 27 members are no longer members of the House on the basis of an alleged defection is a continuation of the determination to prevent them from participating in the proceedings of the House. This is the judgment of the highest court in the land. What does this mean?
Yeah, the implication of that is that everything about the appropriate House of Assembly to present the budget of the River State government has been rested and conclusively concluded. It implies that the duty of the governor of River State now is to present the budget to Right Honorable, to the Speaker, Right Honorable Martin Chike Amehule, and the members of River State House of Assembly to do and perform the duties that has been conferred on them by the Constitution of Nigeria. If the governor wants River State to actually be in peace, if the governor wants to preserve democracy, if the governor wants to live by the oath of office he willingly took to govern River State, the right thing for him to do is to speedily present the budget to the House of Assembly so that River State can progress. Anything to the contrary suggests disobedience of the judgment of the Supreme Court of Nigeria. It also suggests
we'll get to the representation of the budget in a minute, but what is the implication of this on the lawmakers? Because before now, defection has had its implication on Nigeria's democracy. But now that the Supreme Court has stripped the courts of the powers to sack defectors, any implications? Does this mean politicians would be at liberty to defect unchecked?
The issue of defection is procedural. As you are, if you wave the American flag and say that you are now an American citizen without passing through the process, it does not make you a citizen of the United States of America. If you like, wear the flag of the United States of America as a cloth. Paint your house with that flag. It does not make you a citizen of the United States of America. The fact that somebody went to a market and bought a wig and gown, go to court and conduct cases without necessarily being called to bar and have his name enrolled in the Supreme Court of Nigeria does not make that person a lawyer. Now, if you want to defect from your political party to another political party, there is a process that must be followed. If you follow that process, it will take you through the ward level, all through to different other areas before issue of pronouncement of defection, which in this case, even as pronounced by the Supreme Court, is the Speaker of the House of Assembly that will declare a seat vacant. Nobody, not even the governor, can do that. So, since that has not taken place, and there is no proof that these people indeed defected, whatever thing any person is saying about defection or not defection, it's just an academic exercise and an argument for the purpose of argument. We are a country that's under law. Everything is provided for by the law. Anything to the contrary is null and void. Therefore, there is no issue of a defection or no defection. What we have now is that members of the House of Assembly are bona fide members of PDP in Rivers State and in Nigeria. They have participated in all the activities of PDP all this while. Their names are not on the roll of APC.
Okay.
They don't have the APC membership card.
So that has been established. Right, that has been established, Mr. Olisa. But let's talk about the representation of the budget. There is this conversation about what appropriation bill will be represented. Is it the 2025 or the one that has been implemented and spent, which is year 2024? And when the court held that it is an aberration for Governor Fubara to have purportedly presented, so what exactly is the implication of this also?
Sorry, can you come again?
I was talking about the representation of the budget. There was this conversation about what appropriation bill would be represented. Is it the 2025 or the 2024? Because the court held that it is an aberration for Governor Fubara to have purportedly presented an appropriation bill before a four-man House of Assembly, thereby denying 28 constituencies of effective representation, a flagrant violation of a court order mandating him to represent the 2024 appropriation bill before a validly constituted assembly. So the court was not clear about what exact year would be represented.
Now, if you talk about 2024 budget, already by virtue of the pronouncement of the Supreme Court, the governor has violated the Constitution. So that area has been settled, that the man has concluded the act of infringement of the Constitution. If you follow up the activities in the University House of Assembly, they are asking him to present that of 2025. I'm not aware that they're asking to present that of 2024. Because that of 2024 is an act, is an illegal act that has already concluded. So that is held against the governor.
Okay.
So it is the 2025 now that the House of Assembly has asked him to represent. Because in eyes of the law, he has never, it's not even an issue of representing, it's an issue of presenting. Because in eyes of the law, he has never presented the budget.
Okay.
So he has to present the budget for the House of Assembly to look at it and then do the needful.
All right. All right. So before we move on to other matters, yes, the Supreme Court has asked the governor to represent the budget, but are the lawmakers constitutionally empowered to give the governor an ultimatum to represent the budget?
You see, what the lawmakers are acting within the ambit of the law by giving ultimatum to present it. Why do they give an ultimatum? Because already there are acts that suggest that the wrong thing has been done. And the House of Assembly members are now trying to hurry up to ensure that that gap created by not presenting the budget as at when due is cured. That mischief of not presenting at the right time is cured. So they're not acting to hurry up and present so that the affairs of Rivers State government will not be granted. If you want the House is very much interested in is in making sure that Rivers State people don't suffer. So they're asking him to hurry up and bring it within 48 hours is to see how they can cover for the time that has already elapsed.
Okay.
Because this matter is supposed to have been concluded by now.
Absolutely.
This is March. And we're still talking about presenting budget for 2025.
And also, because the court has now restrained the CBN and the Accountants General of the Federation from, further releasing budgetary allocations to Rivers State until a valid Appropriation Act is passed by the House of Assembly. I'm wondering what the implication of this would be on governance in Rivers State, because there is a possibility that this drags on for months. I mean, and we're talking about salaries here, projects left undone.
There is a problem with that. It's not just about the effect on Rivers State government. Rivers State government does not operate in isolation. Rivers State government is government of Rivers State people. And the Rivers State government is establishment of the law. Yes, for the governor to appropriate, there's a provision for that. In section 121 of 1999 amended. Sorry, section 120 of 1999 Constitution amended. So if the governor does not comply with that 121 of section 121 or 120 of 1999 Constitution, it means that its activities are in error. It is an infringement of the law. And don't mind you, everything about the governance of Rivers State has got a constitutional provision. So what the government ought to do to save Rivers State people from that embarrassment, to save the civil servants, to save the governance of Rivers State, to save even the people that live and do business in Rivers State, to even save the democracy of Nigeria, is to comply and abide by the constitutional provision.
Okay.
It is not the government. It's about the people. It's about Nigeria as a nation. It's about our constitution. It's about one acting within the ambit of the law. It's an act of trying to regulate and stop the act of deviancy. It's an act of trying to stop anarchy. Because not obeying the law of the land is trying to create a window for anarchy to set in. This issue of governance has a procedure. If you must be a governor, you must be subject to an oath. You must abide by the rules and of engagement. You must conduct yourself within the ambit of the law. We are not in a state of anarchy. President Bola Tinubu has done his own as president of Nigeria. So have other governors in this country. So what Governor Simfobara is supposed to do is to comply with that oath of office too. Because before assuming that office, you must be subject to an oath. And subjecting to an oath is so that you be compelled to work within the ambit of the law. So it is the governor that is now the challenge, not the governor that is trying to kind of push hardship on Rivers State people and the people that live and do business in Rivers State.
All right.
So the ball stops on the governor's table. If the government does the needful, every other thing will naturally flow in.
Fall into
And
place. All right.
Maybe
we should also look at the invalidity of the local government election, which was another interesting development. The judgment sacked the local government chairman as a result of the pronouncements made by the Supreme Court declaring the election invalid for grossly violating the Electoral Act. For the purpose of clarity and for those of us who are not lawyers, the court held that processes leading to the conduct of that local government election were breached in clear violation of Section 150 of the Electoral Act. Please break this down for us.
Well, you see, if you look at it's just the same thing. It boils down to the same thing. Everything is supposed to be done according to the law. If you just look at the 2023 election, it was conducted according to the provision of the Constitution, the Electoral Act. What the simple thing RISEC in Rivers State ought to do is to just follow the due process, comply with the law, and whatever thing you do according to the law cannot be validated by any court in the land. All right. Non-compliance with the law is an indirect way of saying that whatever act you're doing is an illegal act, and when it is subjected to judicial interpretation or any form of adjudication, it will be nullified.
All right, Mr. Elsie, I'm asking because I remember that the last of what we heard about that case was that the Federal High Court in Abuja stopped INEC from releasing the register of voters for Rivers State to the Rivers State Independent Electoral Commission. And APC's argument was that the necessary legal procedures leading up to the election had not been observed. But there was another court ruling asking the governor to go ahead, conflicting judgment here and there. But the governor went on with the ruling that was favorable to him. Is that on him or legal practitioners and judicial officers who have, turned themselves to prey in the hands of politicians?
If you look at the entire thing, it just boils down to, if you look at the State High Court, for instance, River State High Court, it's covered that River State High Court is under the governor of the state. The governor pays their salaries. And it is very, very difficult. Let us just forget about the issue of jurisdiction first. It is very, very difficult to take any case against the governor of River State to the River State High Court and get justice. You cannot get justice. This brings to the fore the issue of independence of the judiciary. The judiciary in River State is under the control of the River State government. And any case you take against the government to that court, you cannot get justice. So that area is ruled out. Now, talk about the Federal High Court. The Federal High Court is federal. It has jurisdiction to look at the matter. And if you had not got the jurisdiction to look at the matter, the Supreme Court would not have upheld the judgment of the Federal High Court. So all this whole thing, all these problems we have in society, so regulate human conduct, to regulate the conduct of lawyers, to regulate the conduct of judges, to regulate the conduct of the citizens. If everything, assuming the River State High Court operates within the rule of law, we will not have problems with going to that court. If it has jurisdiction, no. Assume it has jurisdiction, without consider it has jurisdiction in this instance. But it does not have jurisdiction in this instance. That is why they want to Federal Court. Mind you, federal government agencies are the ones sued. Mind you, INEC is the one to release the voter register. Mind you, INEC is the only statutory body that is in charge of voters register. So you cannot expect INEC to be bound by judgment without necessarily making them a party. And having made them a party, it presupposes that they will obey judgment of the court. And that is what has happened. INEC obeyed the order of the court and did not release the voters register. And that is why what happened. Among other things, because it is not the only issue of voter register that validated the election. There are other procedures that the RISEC did not comply with.
Absolutely. So let's go there. And I wanted to ask, is it just about the independence of the judiciary? Because there were other issues the Federal High Court ruled on at that time, and even correct. The court held that RISEC had flouted electoral regulations and that the actions taken by the Rivers electoral body were illegal and invalid. Section 60, subsection 2 of the Rivers State Local Government Election Law, which was signed by former Governor Wike in 2018, was another point of argument. The section sought to prohibit aggrieved parties from filing lawsuits related to the local government election. And as at that time, Justice Lifu ruled that the provision was unconstitutional as it contradicted the Nigerian Constitution, which guarantees access to the court for all citizens. So I'm here wondering, does this bring to the fore the constitutional disempowerment of state electoral commissions and its implications?
Sorry, can you come again? Let me hear your conclusion, please.
Is this just about the independence of the judiciary, or also we have to start talking about the constitutional disempowerment of state electoral commissions and its implications?
You know, there's a very fundamental thing about the issue of any law that is inconsistent with the provision of the Constitution of 1999 Constitution of the Federal Republic of Nigeria. Any law that's inconsistent with the Constitution is to the extent of that Constitution null and void. So that every law made by any state must be in harmony with the constitutional provision. And if you make any law that's not in harmony with the provision of the 1999 Constitution, that law will be null and void. It will not work. Now, if you talk about River State government or any state for that matter making law, whatever law they want to make, the lawmakers, the last man, must ensure that these laws are not in any way in conflict with the 1999 Constitution. That's on one side. So when you talk about the issue of independence of judiciary, that one is on the other side. But if you must make law, that law must be in harmony with the Constitution. So if any laws are against the Constitution, it will not work. It will be an illegal law. It will not avoid. If you subject it to judicial interpretation.
So talking about laws, Mr. Osi, RISEC is mandated by law to fix the date for elections in the state, backed by Section 5 of the River State Independent Electoral Commission law. August 9 has been fixed for a fresh local government election in the state. Does the House have any constitutional backing to object to this?
See, you see, the thing about the provision you cited is that whatever law that has been made by the state government must be in harmony with the Electoral Act. And if you look at the judgment of the Supreme Court, it's that if you want to conduct election, it must be as provided for by the Electoral Act that governs area council election in Abuja. But that's what must apply in the states. So whoever is conducting election owes it as a duty to ensure that whatever is doing does not in any way run contrary to the provision of the Electoral Act. The state, yes, can make their own law, but that law must be subjected and work in harmony with the Electoral Act. The Electoral Act is a parent act. This other state was like a kind of a branching of it. So not being in harmony with the Electoral Act is another problem on its own, and also nullifies the conduct of the state election. So that in sum,
so I don't think you answered that question, Mr. Olsen. I asked that question because as we speak, the House has summoned the chairman of the State Independent Electoral Commission, who is Justice Adolfo Senebeli, to appear before it within 48 hours over the conduct of the October 5, 2024 election. The House has also threatened to issue a warrant for the arrest of the chairman if he fails to appear before the House at the expiration of the ultimatum. So what do you anticipate would happen?
There is nothing I anticipate to happen other than that retired Justice Adolfo Senebeli, a law-abiding citizen of the Federal Republic of Nigeria, will just spread himself to the House. The House is not going to do anything otherwise to him. It's to ask him questions about his activities and conduct. And he has the right to be heard. What the House is trying to do is to just give him fair hearing.
Okay.
For him to come on his own side, his role, perhaps, the last election. And after that, you can take it further from there. So there's nothing to fear or worry about that. He has just merely going about his own function, and the entire judge is also supposed to obey. That's all. If he does not obey, it means again that it's another provocative act that could also make the House to take a further step. You know, people are talking about arrest. Yes, the issue of arrest can only come up if the retired judge, did not present himself to the House. If he presents himself to the House, nobody will arrest him. So the best thing to be done is for him to present himself before the court. Nobody's eating him there. Nobody's going to beat him. Nobody's going to arrest him. Nobody's going to submit to his disability. So I think the right thing for him to do is to just obey the House. Present himself there. Explain to the House what transpired. The role he played. At the end of the day, we'll take it off from there. Mind you, we're all Rivers people. Nobody's witch-hunting each other. We're just trying to say that the business of the government of Rivers should be conducted within the ambit of operation of the law.
All right. Let's talk about cherry-picking of court orders. I mean, we saw a lot of that as regards to this Rivers political crisis. Some say, yes, the governor is guilty of that, and others say they blame it on conflicting judgments. But the central argument is that the crisis escalated and lasted longer than it should have. Had there been regard for the rule of law, had there been respect for constituted authorities, Rivers may not be in the position it is today. The position of the Constitution was clear on most of the issues, but how did we get here, Mr. Osi, where the courts have become objects of ridicule by sitting governors?
You see, how we got to that point is because there are persons who have deliberately and willfully made the issue of Rivers State crisis to be a very huge business, where they will have the opportunity of assessing the state treasury. If not, these things are issues that are very clear. Don't forget that the governor is not a lawyer. He has an attorney general who is supposed to advise him to act within the ambit of the law. Now, the question you ask yourself is that did the attorney general give him the proper advice? It is possible that he must have given him. It's also possible that the governor must have listened to other people. There are people, when you have any issue before you, and many people coming to advise you, you have to be very careful to be sure that whoever is advising in your own interest and in the interest of the society. In this context, it is the people that were advising the government that made him to derail. Those people don't love him. Because if they loved him, they would have told him the truth. It is derailment that made him not obey the court judgment. So much so that even the Supreme Court judgment, he's still for dragging in obeying it. And for him to be for dragging in obeying the Supreme Court judgment means also people are pushing him and advising him. There are people that are threatening fire and bring to saying they will do one thing or the other. Those people are the real problem. those people have other interests other than the interest of the River State government and the governor of River State. So the governor must be wise enough to know who is giving him the right advice and who is not giving the right advice. It is because we were listening to wrong advice that took us this far. If you were obeying the court order, immediately the High Court said, look, don't conduct election. Immediately Justice Leaf said, don't conduct election. You must follow the due process. You go and follow the due process. By the time you follow the due process, you have circumvented that provision of the law. You have circumvented that area of the law that is being complained about. You know, but when they say don't conduct election, somebody say conduct. You go to state high court where you have overall power and control and get an order. I mean, these are the problems. So if you look at it very well, you see that some of our colleagues too, lawyers are also a part of the problem. Okay. Some lawyers advise their clients not purely on professional ethics. They advise their lawyers to make money out of the lawyer and abandon the out of the client and abandon the client when the client is in difficulty. If you look before now, we have heard of so many people, Gochire, and others, and a lot many people who are not necessarily Rivers people, who have already been fueling the crisis in Rivers State, who have never said, look, there are problems in Rivers State, let us have peace, who have not advised the governor and the rest of the people to make peace. All they say is, look, the judgment is not correct. The judgment has one problem or the other. Keep fighting.
But as a legal practitioner, Mr. Osi, how does that make you feel? You raised the situation earlier, so let's go back there, where it looks like judgment coming from the FCT favored the pro-Wike faction. We saw judgment coming from states favoring pro-Fubara faction. What does it say about the judiciary and lawyers who present some of these cases, which at the end of the day, the court describes as, you know, either statute bar or lacking in merit or not within the jurisdiction of the court? Does this embarrass you in any way?
No, there's something about it. If you go to, you see, anything that has to do with Federal High Court is Federal High Court of Nigeria. Federal High Court for everybody, including Rivers State. But when you talk about Rivers State High Court, it's peculiar to Rivers State. So what happens is that if you want to really be fairly treated, if the judge has to be bold in doing his act, you have to, provided the judge has a jurisdiction, you go to the Federal High Court. That's for everybody. Not the State High Court. That is for a few people. So the important thing in filing any case before any court is jurisdiction. If the court has jurisdiction, for God's sake, let the court inquire into the matter. So the issue of saying, oh, if it goes to Abuja, it favors one person or the other, is neither here nor there. Where the problem really lies is in the state. Because if the judge does not comply with the governor, he'll be punished. All right. If the issue of Federal Court is federal, everybody, that is Borno State, KB State, they're all involved. They all have interest in it. But that of Rivers State is just peculiarly for Rivers State people and Rivers State governor.
All right. So because we're looking for a lasting solution to this crisis that lasted for about 2 years, what should the Rivers State House of Assembly and Governor Fubara do at this point to avoid further escalation? And I'm asking that question because now we've seen some Ijaw groups highlighting ethnic coloration. You see the Ijaw National Congress, you see Ijaw Youth Council are threatening violence. You see members of the South-South Reawakening Group are saying we're not in support of violence. And I'm wondering how dangerous that is.
That is just trying to be childish. You see, these are hired people trying to speak for their pockets. Because if you look at the issue of Rivers State is a multi-ethnic state. There's no ethnic nationality that dominates Rivers State. In fact, Rivers as it is today, the largest ethnic nationality in Rivers State, now you talk about the largest ethnic nationality in Rivers State, talk about the Ikweres and the Ugonis. And if you have been following up the events that have been going on in Rivers State, you have not, I don't think you've ever had Ikwere people threatening anybody or the Ugonis threatening anybody. I am from Oba. My own is another ethnic nationality in Rivers State. What is going on in Rivers State is not an ethnic thing. It is just few people who are making money out of the governor that are trying to pretend as if they are working for the governor. And you see, and nobody has the right, no matter how highly placed, to threaten anybody. We are a lawful society, we are not a lawless society. And I want to even use the opportunity to call on security operatives to invite those people to question. There is nothing like a job fight. Nobody is fighting any fight in Rivers State. Majority of the people that have benefited from the Minister of FCT are job people. I'll give you an example, very clear example. The EDF of NDDC, Chief Bomaya, he's an Ijaw man. Professor Ogiri, that has a position in at the federal government level through the Minister of FCT. It's a job. In fact, out of the about 11 appointments that the Minister of FCT has brought to Rivers State, just be patient with me, please.
Okay.
Out of about 11 appointments, I'm not very sure now that the FCT Minister has brought to Rivers State, about 7 of them are occupied by jobs. And the Rivers State will have not less than 12 ethnic nationalities that make up Rivers State. Just look at it. So those people who are talking about ethnicity are doing their own thing. They are not representing Ijaw people. In fact, we have Rivers Ijaw Congress that's even over and above that has more population than the ISC in Rivers State here. If you talk about the Ijaw is not, the
all right, because of time, Mr. Osi, because even after this Supreme Court judgment, there are those who have talked about a political solution to prevent Governor Fubara from being impeached. We've heard from Ogoni stakeholders who have appealed to Mr. President to wade into the Rivers situation. And I'm wondering why. Do you see a looming impeachment proceeding?
Any person who is talking about political solution is engaging himself or herself in a wishful thinking.
All right.
They cannot preside. They cannot sit over the. They cannot sit on appeal over the judgment of the Supreme Court. We have crossed that Rubicon.
All right.
Supreme Court has given the final judgment, and that judgment is final. What ought to be done now is to really justly implement the decision of the Supreme Court. I think what the government ought to really do is to abide by the decision of the Supreme Court.
All right.
By the time it shows good faith, in trying to obey the judgment, then this issue of saying, okay, political solution can come in. It will be a matter of looking at the matter and see if there's anywhere they can give you soft landing. But even at that, there's need to preserve and protect the society. There's also the need to preserve and protect the constitution.
All right, Mr. Osi, thank you. Thank you very much. Great conversation tonight. I've been speaking with Osi Olisa, constitutional lawyer, political affairs analyst. Thank you so much for your time on Politics Tonight. We appreciate it. Thank you so much.
My pleasure. Thank you so much for having me.
And thank you very much for watching, everyone. That marks the end of today's episode of Politics Tonight. But before we go, let's tell you that the views and reactions of a resource person is his and have no connection with TVC News. Meanwhile, you can watch the repeat broadcast of this episode at midnight. Get in touch with us on our social media handles, Facebook, Instagram, and X at TVC News NG and at Olajumoke KW using the hashtag Politics Tonight. We're also on YouTube at youtube.com/TVC News Nigeria. I am Olajumoke Olatunji. Good night, everyone.